7 copies of everything, one for each board member, one for the code enforcement officer, and one for you. So if that never happened,
Yep.
you'll get it next week.
Okay, great. That'd be good. Thanks.
Thank you. David?
Dave James, Kennebunkport. Just a thought that, you know, if there is some possibility of putting a porta potties at the mid-beach location, I would certainly think you'd want to do that before we ask the voters to approve another $70,000 to go into a contract zone at the Goosestock store. And that was a number that was thrown out 2 years ago when we first started talking about that contract zone. I imagine it's probably closer to 100,000 by now. But I would suspect that a mid-beach location would significantly detract from the usage of a porta potty down at the east end or the west end of the beach, because most of the people are in the mid-beach location.
Thanks, David. Anyone else? Steve?
Steve Hodgson, Kennebunkport attorney. I'm representing David Green and Gene French, who were the owners of the property on the corner of Edgewood and Kings Highway. And as Larry was alluding to in his review of records from a few years ago, I was representing him back then too. And when this came up, there were some other issues raised that actually resulted in some zoning changes that were a problem at the time. But there were other problems that were raised, and I guess I need to raise them again. One is that the town at that time had not established, and to my knowledge hasn't since, what, if any, ownership rights it has in Kings Highway. I mean, nobody has, to my knowledge, had a record of when the town acquired an interest, whether easement or otherwise, in Kings Highway. And I suspect, if there's any record at all, that it's quite a while ago. And the law in the state of Maine changed in 1976, but prior to that point in time, any municipal easement rights taken in a road were only easement rights and were not fee simple rights. So first of all, I think the town has to establish that when it acquired any rights, and then assuming that those rights are easement rights. It doesn't mean, of course, that the fee simple owners can block any usage of it, but what it does mean is that the easement can be used for the purpose for which it was acquired. And I think it's obvious that the purpose was for purposes of, you know, having a public way. And a case that I cited 3 or 4 years ago, whenever this came up, and that Larry was alluding to, I had cited it, and I think Bill Plouffe had written some kind of response, disagreed with it, but again, that's where it was left at that time because it didn't get any further. But I would like to cite it again, which is the case of City of Rockland versus Johnson, which is a 1970 Maine Supreme Court case. And basically it dealt with the issue, again, this is prior to 1976, so it is dealing with it as if it is you know, a public way. The town's rights are easement rights and not fee simple rights. And amongst other things that it observed in that, it said that the common law rule was that the public acquires only an easement in land taken for the establishment of the highway, except as it's been changed by statute in some states. At that time it hadn't been changed in the state of Maine. And it goes on to say the owner of land over which the highway is laid retains his right in the soil for all purposes. In this case, by the way, the facts are not terribly, in my opinion, dissimilar from this. This was in Rockland. There was a street that had actually been abandoned, and the city of Rockland was establishing a bathhouse and bathing facilities within the right-of-way of the road. And the court said and I remember because I had to look this word up at the time, I wasn't familiar with it. It said the only right the city of Rockland had in the land, which was the subject of this dispute, was a right to the viatic use of the road by the public. And viatic, as I looked it up at the time, I'm going by memory, but basically is used for travel. Viatic has to do with travel. And so I don't think that establishment of a structure within a traveled way or a way intended for travel is consistent with that use. I know there may be disagreement, or there has been before, but I think that's at least a substantial issue that the board ought to be aware of when it's looking at the different options that it has. I do know the Jeffries Way, I remember that coming up before, and I haven't seen the signed agreement. My recollection was that there was a court judgment, as Larry indicated, and I don't recall that, other than it clarifying that the association had the fee interest, I don't recall. It certainly didn't say anything about what the town couldn't do within the right-of-way. So at least in that case, there's been a court decision about who owns it, what kind of rights both the owner, the fee owners, and the town have. In the case of Kings Highway, that has never been established, and certainly would have to be established, and then overcome what I see as an obstacle in terms of using the town right-of-way for other than purposes of allowing the public to travel over it. So anyway, that's basically our position on that, and I can, when it's appropriate, or town council, I assume, will get involved at some point, but I mean, I can certainly provide copies of the case and so forth, but that's basically my client's position.
Any questions? Thank you.
Thanks, Steve.
Any other comment from the public? Questions? Well, we'll
Table it, I think, for the next meeting.
I agree. I think we should carry this on at another meeting, and Larry can provide us with some more detailed information, as you suggested. And okay, moving on to other business.
Can I ask one question about the...
Of course.
Does the board want me to engage our attorneys in any way in terms of